welcome back to Law Unfiltered. So we are back with another interesting topic. When does a company die and what happens when it die? Well, in normal layman term sense, it means when does a company wind up or close down? So a lot of people assume that when the company closes down, it's always because that there's no money, they are insolvent, but it's not always true. Even if the company is solvent, there are grounds for anyone to try to close it down. And so today we are going to talk about that together with what happens after the company closes down, together with a few guests this time. It's quite exciting, right? Starting with Rishi. Hi, thank
Hi,
you for being here.
thanks, Celine. Thanks for inviting me to
Yeah.
speak. Yeah, a bit of background. I run Rishi and Partners as a principal, and our work focuses on corporate commercial litigation and insolvency, post-liquidation work is part of our portfolio and what
Yeah.
we handle.
Yeah. Thank you. And also we have Anupal from Baker Tilly.
Hi, hello
Thank
Celine.
you. Thank you for
Thanks
coming.
for having us. Yes, I'm a partner with Baker Tilly,
Yeah.
Malaysia, and I'm also a licensed liquidator myself.
Mm-hmm.
So been involved in this industry for at least 19 years.
Wow.
Yeah, been here since the beginning.
Yeah. Do you like it so far?
Yeah,
Is
lasted that long.
Okay, yeah, that's true. Yeah. And also lastly we have Daniel from Baker Tilly as well.
Hi. Thanks, Celine, for having us.
Thank you for coming.
Yeah, no worries.
Yeah.
Was excited when you extended the invite.
Really?
Yeah, wouldn't have said no to that.
Of course not.
Yeah. So I'm also with Baker Tilly. Already 13 years. So time fly. Yeah.
Nice. Do you
Happy
enjoy
doing what
it?
I do. Yeah,
Do you enjoy it?
for sure.
Right? Is
Yeah.
are you saying it because Anupal is here?
No, I'm pretty sure that's not the reason.
No. Definitely not. Yeah. We all make our own choices. Yeah.
Okay, that's what you say. Now, let's start with the first part. When the company closes down, okay, there's two ways a company can close down, right? It's either by voluntary winding up, which is if the creditors have all decided to close down the company, or it can be that the court has ordered for a compulsory winding up. So there's these two ways for you to close down a company. But the grounds to close down a company is what is essential, because not any whatever reason can close down a company. Usually winding up is the last resort that the court will give, right? So let's go to the first ground. The most easiest one is when the company cannot pay debts lah, right? Correct or not? So yeah, let's talk about that.
Yeah, inability to pay debts
Yeah.
well, that is the most common ground, and you have situations and where the consideration is whether they want to voluntarily wind up or wait for a creditor to present a petition. And the consideration, more often than not, when it comes to waiting for creditors to present a petition, depends on what is the state of affairs of the company insofar as that point is concerned, insofar as the extent of the debt which they are facing.
Whether they are able to pay back or not, right?
Yes, so whether they want to fight it to say there is something in the pipeline, or we are trying to work out a scheme of arrangement, so on and so forth. How aggressive a creditor is insofar as what they want to pursue.
Right.
So inability to pay debts would involve...
May not really be the ground to wind up as well, right?
Well, depends, you see. So if you are in a position in which your revival involves a long-term plan which a creditor does not want to wait that long, they may pursue a petition to wind up and consider perhaps that post winding up that they are either secured or unsecured debt can be realized sooner, and this would be part of the considerations when it comes to inability to pay debt. That's the first ground. Of course, there's that other ground.
True. I remember that time during COVID, right? There was a petition filed against AirAsia X, right? I remember it was during the COVID time, because and then they couldn't pay some of the creditors, because obviously nobody's flying in and out, right? And then after that, there was a winding up petition. I recall that this happened lah. Maybe I will check again. But the court didn't allow the winding up. Obviously, AirAsia X is still here, but on the grounds that actually AirAsia X can earn money. It's just that at the time there was COVID, the cash flow was not that good, so the court actually did not allow the winding up process. Instead, I think they went through like the scheme of arrangement or the other scheme, if I'm not mistaken. Just a quick correction before we continue. So previously I said that somebody filed a winding up petition against AirAsia X. So I checked, that's not entirely true. So what really happened is that there was no winding up petition, but instead there was a dispute involving creditors seeking for payment and so forth. So the issue actually relates back to AirAsia's scheme of arrangement. So AirAsia itself was actually not subject to a winding up petition. So I've also included the link down in the description below. So if anyone wants to find out what really happened, go check it out. So we'll go back to the video now. Thank you.
Yeah. No, well, the little that I know, they did,
Yeah.
they filed for PN17, if I'm not mistaken, and then they did have an exercise.
arrangement.
Yeah, scheme of
Yeah.
Yeah, let's
scheme
talk
of
about more about this scheme of arrangement, because this is something that the court will consider if you want to wind up a company which is owing a lot of money, but they actually have a lot of potential to earn in the near future if there is some sort of arrangement that is done, right?
Yeah, well, one such thing would be your judicial management.
Yeah.
You know, so you have to have someone who comes up with a plan as a judicial manager and present it, and that must be accepted insofar as creditors are concerned. And it's a process as well. There has been quite a number of practical problems which have arisen insofar as genuine judicial managements are concerned. And I would say then this is my view, is that the law is ironing itself out insofar as settling as a settling area. But once you put that, there's that moratorium. And that's why it's not as simplistic and straightforward as the court saying, okay, there's a winding up petition and inability to pay debts. And
just straight away.
yeah, so the moratorium is strong. It's actually a block against winding up petitions, you know?
True.
Yeah.
So does Baker Tilly handle like judicial management and also
Yeah,
scheme
we
of
do a lot of
arrangement?
judicial management and scheme of arrangement works.
Yeah.
But it's also a preferred option really because like Rishi mentioned, it's mostly because of the moratorium. It gives an immediate protection. Is it necessarily a way to evade winding up? That's where I think he's saying that sometimes it's been misused as a way to delay. You can't run away, you can at most delay it.
Yeah.
So I think sometimes it does get abused for its the availability of the moratorium, then it does get abused for this kind of processes.
But why, if let's just say if the company really has no ability to pay, and but the scheme of arrangement or judicial management is opted, then I mean, why would they go through that process and pay for more legal fees, more other appointment fees, just to get that defense?
I think at most times when a company do apply for JM, they are in the midst of speaking to a white knight, or they are discussing some sort of arrangement, but the plans may not be solid. So they are engaging with people, and they are holding very closely and very tightly to wanting to go through. So
Okay.
they themselves put in a lot of efforts in trying to defend the company.
Okay,
on that
I can
sense.
understand that. Okay.
Mainly cash flow issue lah. So they just need some time to
Yeah,
To
buy
go
go
time.
about things. Yeah.
You mostly 1 year, 2 years, right? If I'm not mistaken.
The whole jam process.
Or scheme
Um,
arrangement. I remember scheme is like 2 years, but you can extend for another 6 months.
Yeah.
The general requirement or the general law is 1 year, but for both jam and scheme, it does extend
For
further.
the 6 months, right? So
Also,
inability.
sorry to add another thing. I mean, what matters as well in assessing whether they want to go for a scheme of arrangement, judicial management. A lot of things. Sometimes it turns upon the structure of the company. Is it is it a subsidiary which is suffering,
Okay.
and which may affect
Holding.
holding in a particular way. Those could be a situation which is different from your typical company seeking to save itself from the white knight situation. So the interesting thing about this area of law is that the permutations and the situation, it differs. It can differ from one to another. So you talk about Air Asia is very different from a scheme of arrangement for judicial management for your normal Sandrian Berhad. And Air Asia is something where it's got
So big already.
so your group and structure is so big and it's
Yeah.
different. So you
Yeah.
have Air Asia in it, and then you have Air Asia X, and so
Yeah.
these are things to look at on
Consider
a
as
case to case basis.
Yeah, correct. That's true. So it's not every time when somebody say that this company cannot pay the debt means you can definitely get a winding up process, because the court will also try to assess what is best for the company as well. I would say that,
Yeah,
right?
yeah.
Now,
The
let's
bigger picture.
yeah,
Yeah.
looking at the bigger picture, correct. Now let's go to the second ground, which is just and equitable.
Mhm.
I recently read about it. It's kind of confusing. This is, I mean, it's not confusing in per se, but it's like so complicated because usually it happens with like family and friends business, right? Because just and equitable usually means like if, for example, if two-person cannot work out together with each other anymore, there's no reason why you want to continue with the company because it will come to a deadlock. What I mean is that if, like, say, for example, a company has two directors, they are either friends or family, right? They are also the shareholder. What if one person, if both of them fight and they have equal shares, like you cannot make decisions anymore. What is the point of having that company, right?
Yeah.
So yeah, let's talk about that.
Well, that when we say just and equitable, yes, the broadness sometimes
Very broad.
it leads us to confusion that it could be anything and which is put
Exactly,
there, and
yeah.
it's not quite. The courts have given some sense of guidance and direction. Not everything can suddenly just be lumped up
Just
and
and
say it's a
equitable.
kitchen sink
Yeah,
approach and say,
yeah.
I am
Agreed.
upset, so let's go on just an equitable grounds. No, deadlock in management is a very
The most basic one,
common,
right? Common
yeah, and deadlock in management is the easiest of
ways.
just and equitable to assess for the court, because over time you say, to what extent is the deadlock here? What is going on? Is it board composition? Is it shareholders? Are they at where? What is the dynamics which is causing this so-called alleged deadlock? Right? And there could be other situations, insofar as just and equitable is also pushed, because again, sometimes it goes back to the structure of the company, right? I don't want to mention one matter which I was a call to assess. It's an education institution which is humongous,
Okay.
right? And because of the passing of the main actor who built the whole thing last time,
Okay.
it suffered nearly a complete fall, right?
Oh.
And when we were called to assess, and that one of the assessments were whether it's going to be possible to wind up the company at just an equitable ground. The consideration there was not so much deadlock in management per se. It is insofar as other collateral actors and factors which are causing for non-continuity of business operations.
Okay.
Yeah, I can't go too much in detail insofar as that is concerned, but it could involve insofar as employee personnel, third parties are concerned, vendors grouping in a particular way, having their agenda. So that's why I say this area is fascinating, because from one case to another, you can have a lot of differing factors.
Anything can be established as just and equitable. Can I say that?
Well, it
Case
is.
to
It
case
has the
basis.
court has stated that the broadness still is retained, but not everything can come decided. Because of that, we're going to push for insolvency.
Are you talking about like the factors, that elements that they have to satisfy to get to like just and equitable? Like, for example, I recall that there's this element, it has to be quasi-partnership.
Quasi-partnership also. These are
Yeah.
non-exhaustive elements which are typically examined.
Right.
Yeah.
Yeah. So that's also one ground which not everyone can get it lah, I would assume so. So let's go to the third one. Directors acting in their own interest. This is, I think, the most common one. And I think a lot of people don't understand. Previously I had someone that I know of was in a business with his friend. And then after that, they fought. There were some disagreements. I would say that's a kind of like a deadlock lah, because they're both directors. They're technically not so much, because my this person that I know of, he's kind of the majority shareholder, and then the friend is not. And then after that, they fight. They cannot make any decisions because the bank needs two approvals, right? So they cannot do anything. Okay. Then after that, this fella started taking out money from the company. Friend also started taking out money from the company. I'm like, why you guys do that? Because it's like, we're not friends anymore. I don't want to work with him already. I just take out money lah. I put it back to my own company. I was like, no, it doesn't work that way. Okay, you are the director of the company. There is some sort of fiduciary duty under the Companies Act that you have to satisfy. You owe that obligation to the company itself. So whatever belongs to the company, it stays there, right? You cannot act in a conflict of interest. I think a lot of people doesn't grasp that idea when they start a company and become directors.
Right. Yeah, well, the important thing insofar as directorship is concerned is to understand the extent of the exposure from the obligations you have to the company.
Right.
It's not as simple as, again, I'm director, and some of them come say, I'm
They feel
sleeping
very happy,
director.
oh, I'm the director of
I'm
the
either
company.
not involved, or if I am involved, then this is my company, so I
Yeah.
get to do as I please.
Yeah,
Not quite. Insofar as fiduciary duties are concerned, acting in the best interest of the company is just quite wide, right? So that aspect. What about you guys?
I think most of the time, in the example that Celine has provided for, in layman term, they just run it as if it's their own. Even when there's, 2 partners, 3 partners,
Yeah.
they all think it is their own.
We're friends.
Yeah.
It's okay lah.
So when things breaks down, then no one knows the legal implications.
That's true. They don't know what is the legal implication.
They thought if I'm a director of a company, then
I can do whatever I want.
Yeah, I can do whatever I want.
Yeah.
But I don't think they are well aware at the point where they set up the company or the business that they know what the legal implications are.
Mm-hmm.
Yeah.
I
So they
think,
can't plan for it.
yeah, and we have actually met business owners who, let's say, they do dip their hands into the company's money, and for them it's like, it's my business, it's my money.
Yeah, yes.
What do you mean I can't touch it?
Yeah.
So the first thing is, I think they forget the concept that as a director, you are actually an agent being put in place by the shareholders.
Correct.
And then the second thing they forget is that it's two separate legal entity, and there's a
Correct,
corporate
yeah.
wheel in between.
Mm-hmm.
So then this is where the first breakdown comes
Comes
in.
from, yeah.
They assume it's their capital, it's their money, and
Yes.
therefore everything in the company now belongs to them. But
Yeah.
that's far from from the reality of it.
I think there's also another misconception. They can, the conflict of interest part, they can just hire anyone they want, like family and friends, to come and do the business for the company and all that, right? I think that happens quite often as well.
Yeah, mostly family-run businesses or small businesses. They do have that
conflict of
conflict.
interest.
Yeah.
I think they don't understand that if there is a conflict, you need to address it to the board of directors.
Like a declaration.
Yeah, like a declaration, especially if there's outsiders, there's going to be a lot of problems, So,
Seeking to get a clearance of the conflict, addressing it, seeking to get the clearance, whether you can even plausibly do that. And the other part also is, what Anup was saying is that sometimes when they're wearing two hats as director and shareholder, and they don't know the demarcation between the two, what it means actually.
Yeah.
The duties and obligations of a director
And the shareholder
is
different.
heavier because of the day-to-day management, what
Yeah,
you're requiring,
correct.
as opposed to shareholder.
Yeah.
Now, when you are both, it goes back to what she's saying. So this is my capital, my money, and then I'm also director. So
Haven't reached
what?
the dividend date yet.
Yeah, and that's what they don't see, right?
Yeah.
That's where the gap is, because they don't see it as only taking your money when dividend comes. They start pinching and pinching and pinching, and
Yeah.
because they cannot make the distinction. They're wearing two hats and they can't tell it's two different roles.
I
In fact,
think
three. There's the company, there's the director, and the shareholder. There's three different parties here.
yeah. And more often than not, because people don't understand this distinguishment, the differences, so it will lead to another ground to wind up the company sometimes,
Yeah.
not all the time. I mean, when you file a petition, you can put in different grounds, right? Many grounds, as much as you want lah.
Yeah,
Most-
well, yes. I mean, generally, you try and put it that the
Put everything in.
mismanagement comes under just and equitable
Correct,
as well.
yeah.
So yeah.
That's true. So I hope everyone knows what's their duties after this.
Another thing, insofar as that aspect of why you see directors, shareholders do this, this again, my observation of the education they get from who their lawyer and accountant is, because lawyer and accountant play a big role in terms of telling them the extent of the exposure and obligation. Lawyer first, okay, lawyer is one aspect. Accountant sometimes. You have the flip side of one is those who are unaware and do not know and just feel that that attachment insofar as my money, my business. The other ones who are the other types who okay, I've learned this from my lawyer and accountant, and you take the concept of advances, for example, or selling off their own personal assets to the company,
Okay.
So yeah, this goes a bit deep, but it all goes back to how
How well they've been advised.
exactly how well they've been advised, what they've been told, what is their picture in their head complete in terms of what they can and cannot do, and whether it's legitimate. You see,
Yeah, but
So-
nobody will go and hire a lawyer when they want to open a company, right? With their friends, for example.
But I think it starts with the company secretary.
True. Yes.
Yeah.
Correct.
Yeah,
Sorry, I missed
That's
that.
the
Very
first part.
key player. Yeah.
Yeah.
But how much the company secretary gonna tell these two person who is going to be the directors of the company?
It appears that they don't tell anything much.
Yeah.
Other than, hey, I want to open my company, fine, I'll do the paperwork for you. And then, yeah, you need me as one of the person in your registrar, so I'll be there.
It's like more compliance, right?
Yeah,
But I
more
think
compliance.
maybe a lot of the directors or business owner they should seek the
Legal advice first.
No, the advice of the company secretary as well, because they're the first party that you go to set up a company. You can always ask certain questions.
But like she said,
Yeah.
they are not saying
They
telling
don't wanna
much.
tell. That's the other thing.
Yeah. No, like, I think it's understandable. Apart from doing agreements,
Yeah.
partnership agreements, I don't see why would they go and ask like, oh, what obligations do I have? Because like you all said that, I think this is my company, this is my money. Why I cannot take?
Well, to me, I feel it's a culture thing, right? You go to Singapore, they definitely have expectedly even if it is a solicitor friend or someone advising on the landscape of regulatory and compliance and all of that. Here, it's cost,
work based on
right?
trust.
So what is the minimum cost I need to pay to set up a company? I don't need to know about regulatory compliance.
True.
Yeah. So at least for me, the more prudent ones here, the basic they could do is have a more experienced COSAC and accountant. Lawyers, like I said, a culture thing, so not that much just yet, but still, these three would be very paramount.
I mean, I recently realized that a few $100 can save a lot of headache. Sorry, a few $100 of legal advice can save a lot of headache.
Yes.
Am I right?
Yes, absolutely. Not the few $100 now is ChatGPT.
That's also true.
Yeah.
The one don't need a few $100. The one $100 a month enough already. Right? Now, okay. Now that we know what are the grounds to wind up a company, so the question is, what happens after the court orders for the company to be wound up?